Introduction to Environmental Law, Module 4, Environmental Protection, Command and Control. In the last module, we considered how private law, the law that regulates the conduct and interaction of individuals, may be used to protect the environment. Here we are going to begin to consider how public law, law that regulates citizens' and society's interactions in relation to the environment, benefits all. Regulatory frameworks established by statutes, regulations, and policies tend to create an overlapping web of rules and processes that govern our behavior, activities, interactions with the environment. Most commonly, this happens through two governance mechanisms: command, setting standards, and control, ensuring compliance. There are two main types of regulatory frameworks or regimes used to implement command and control. These are media-based or sector-based. In most jurisdictions, approvals are key for media-based and sector-based regimes. Media or resource-based legal regimes are based upon environmental media such as air, water, and land or forests and oceans. Arguably, though, distinctions between media are artificial. What occurs in one often affects another. This approach can result in a somewhat piecemeal and at times fragmented approach to environmental law. Practically speaking, one facility may require many different approvals based on different legislation. Recently, there has been some experimentation with whole facility permitting to create more integrative environmental regulations. Beyond media, environmental laws can be categorized by sector, such as energy, endangered species, etc. These may be customized to the area of regulatory interest within a given sector. They will typically incorporate elements from media-based and approval regimes and target the protection of air, water, and land. Most commonly use approvals to achieve objectives. Laws governing the protection of the environment are prohibitory for the most part, but the prohibition is rarely absolute. There is usually an out clause, where otherwise prohibited activity can occur if government permissions or approval is received. Approvals are granted through an application qualification process, and although issued by an administrative officer, usually require the consent of the minister. Approvals may be simple or comprehensive. Permission to engage in an activity may also establish conditions that must be adhered to. Once the approval or permission is granted, it is enforceable and becomes as legally binding as a provision in a statute. Failure to comply may result in the cancellation of the approval, along with a fine or other sanctions. Approval-based regimes usually use media-based approaches. Officials issuing approvals often rely upon media-based regulations, policies, and guidance documents. Environmental issues historically have been associated with members of upper and middle-class society wanting to protect health and property. This began to change in the 1970s with the emergence of the environmental justice movement. Environmental law is often connected to issues of social justice, public rights, and the protection of the public interest. The 1970s also ushered in proactive requirements for developers to assess possible impacts of development: environmental, social, physical, and economic. This trend has resulted in a body of laws that are more holistic, integrative, and preventative, including environmental assessment laws, urban planning, land use planning, parks, and other protected regimes. The importance of participation rights of private citizens has grown and evolved and become an essential component of environmental decision-making. Public participation is particularly important in environmental approvals to build confidence and acceptance of the results. Public participation rights differ across Canada and within individual provinces based on the regime in place. Almost all environmental protection regimes in Canada have followed the command and control structure. Typically, statutes set out general prohibitions and empower government officials to establish regulations with more specific standards. Ideally, standards are set with reference to the identification of uses of the ambient resource to be protected or objectives to be met, formulation of criteria through collection and/or generation of scientific information, formulation of ambient quality standards from these criteria, formulation of effluent standards for discharges into the environment that will produce a quality meeting the ambient standard, and finally, development of monitoring and other information gathering programs that will refine the data inputs to the previous steps and provide feedback on whether the objectives are being met. Setting and monitoring allowable standards is critical. There is the question of whether cumulative effects will be adequately taken into account if standards are used in relation to individual scenarios only, and also whether the effect over time is adequately considered. Often, the success or failure of this form of environmental regulation hangs on the effectiveness of continued monitoring and feedback. Unless there is sufficient information fed into the system, it will be virtually impossible to know if the other elements are adequate for the purpose. An overall concern is that the process involves a significant blending of politics and science. In the latter case, there is the issue of the imperfect state of scientific knowledge. For as much as we would like to rely on scientific certainty and fact, the reality is that in most instances, what we are dealing with is best guess and minimizing risk while maximizing opportunities. Given that we are willing to accept some level of environmental impact in order to facilitate our economic or other interests, it then becomes a matter of how much, which is a political decision. Politics and science can be a heady mix. Through it all, we must hope that the best efforts of both will help educate the public as to what is an acceptable level of pollutants that we can tolerate. Environmental laws also typically give powers to enforcement officers to carry out policing functions, the control element. Crown attorneys are usually charged with prosecuting individuals and companies that fail to comply with the rules. Parliament and provincial legislatures set the framework for the command and control model through the passage of statutes. Statutes will authorize the development of regulations. Regulations are created by those named in the statute. Often the responsible authority, empowered through the statute, is the executive branch of government, the cabinet. Regulations are set for any number of things: pollution control, standards for construction, waste management activities, limits on effluent discharges. The power to issue site-specific legal instruments is also given through the statute, often to a director. Standards established in relation to these will be set on a case-by-case basis. For example, environmental approvals or administrative orders. Policies and guidelines are not legally enforceable, but can still influence environmental behavior and may be a precursor to legislation. By way of example, Blue Book guidelines for discharge of contaminants to surface water developed by scientists and civil servants and approved by the minister may be translated into a water policy. Though not enforceable, they still have an impact. They may be adopted by the director for granting approvals. They may also be considered by the courts when determining whether an alleged offender was guilty of the prohibition against discharge. Performance standards, such as a pollution limit imposed on a polluter, are often supported by industry because they allow flexibility. They may be more likely to encourage innovation and adoption of novel technology or processes that will ensure they are met. Construction standards require that a government-approved pollution control system be used. Critics note that construction standards entrench pollution control approaches and technologies and may stifle innovation. However, they may be easier to enforce. Implementing pollution prevention standards is a relatively new approach to standard setting since the early 1990s. These have been recognized and applauded, but have been slow to gain formal acceptance and implementation. They change the focus from control of the quantities of pollution at the end of the pipe to prevention of the use of potentially harmful substances in the first place. Establishing environmental quality-based standards has proven to be contentious, lengthy, and expensive. A different kind of environmental quality-based standard is the health risk assessment standard, linked to the standard that is created as a result of the environmental impact. Gathering information for this type of standard is also expensive, and long-term health effects are difficult to identify. These different problems suggest a new approach may be needed, and the precautionary principle has emerged as a guiding focus. The precautionary principle is applied when it appears there may be a real risk of harm to the environment and science is unclear as to whether the harm is likely. In such instances, the decision should be not to proceed until the uncertainty is resolved. Technology-based standards are useful if there is an agreement on what is the best available technology. This removes controversial political and scientific judgments. However, there are two problems. They may be developed without considering the needs of the environment, and they may entrench prescribed technology and close the door on better solutions. Points of impingement versus control at source asks where to draw the spatial boundary for meeting discharge standards. For example, air pollution standards are often based upon point of impingement models rather than the end of the stack, but pollution does not respect property boundaries. Despite strong agreement that the surest means of preventing harm from air pollution is by controlling environmental contaminants at their source, most jurisdictions are reluctant to base air pollution standards on this principle because of economic and social costs, among others. Informational standards have been used as alternatives or supplements to pollution control requirements. They involve imposing legal obligations on industries to disclose information about environmental practices, such as pollution discharged or emitted. Incentives and financial assistance. Government programs exist to assist potential polluters in meeting pollution control standards. Sometimes governments have a difficult time explaining why tax dollars should be spent subsidizing businesses. However, where the result is of general benefit to the community, such expenses may be justifiable. There are a number of different types of programs, including grants, tax incentives, sharing expertise, and research. Licenses and approvals have both a carrot and a stick component. An environmental activity cannot proceed until an approval is granted, and therefore proponents have an incentive to ensure minimal environmental impact, a carrot. Environmental approvals most often come with conditions attached, and if these are not met, environmental officials usually have the power to take both administrative and enforcement actions. A stick. One drawback is that often there are insufficient resources for proactive monitoring, and therefore a great deal of reliance is on the operator to self-monitor or the public to provide information to enforcement officials. Administrative orders impose legal requirements on individuals or companies to take a specific action, for example, control pollution discharges, repair damage, remediate areas. This can be more punishing than a conviction. They start with an investigation by enforcement officers involving a tailored administrative response and are based on evidence of a breach of environmental law or regulation. Most environmental legislation, including the Nova Scotia Environment Act, provides an avenue for appeal, usually to the courts. In Nova Scotia, administrative orders include control orders, stop orders, litter abatement orders, emergency orders, temporary approval orders. If prosecution is preferred, the Supreme Court has recognized 3 types of legislative offenses which may be prosecuted. First are mens rea offenses, where there is criminal intent. The second are absolute liability offenses, where the legislation states clearly that those charged are to be found guilty once the act has been proved. And finally, and for the majority of cases, we're dealing with strict liability offenses. Under these, the courts are allowed to consider the defense of due diligence, which will lessen or avoid liability or sanctions. Due diligence refers to the notion that the defendant has taken every reasonable step to avoid the act which resulted in the environmental harm or damage. Prosecutions employ the full weight of government power to compel acceptable environmental behavior. They cast a negative moral judgment on an environmental action. The purpose of prosecution includes both specific deterrence and general deterrence. Preparing for a prosecution may involve inspections and searches, seizing evidence, and gathering evidence. There are 2 standards of proof in relation to prosecutions. In criminal cases, the standard is beyond a reasonable doubt. Beyond a reasonable doubt stands for the notion that should the court find that there is some reason why an accused not be found guilty, then they must recognize and acquit. The balance of probabilities applies in civil or strict liability cases, and the intention is to make things right between the parties. Was it more likely than not that the person charged with the offense was more likely than not to have caused the act? The reason for the difference between these 2 standards relates entirely to the significance of the potential results. In criminal cases, it could mean incarceration. In civil or strict liability cases, the consequence is more likely than not a fine. Most environmental offenses are prosecuted as a consequence of non-compliance with a legislated requirement. These are strict liability offenses. The prosecutor need not prove mens rea, or intent. Once the actus reus is proven, the act that is being complained of, the burden of proof shifts to the defendant, who must show that they took all reasonable care, in other words, due diligence, to escape liability. Environmental law is interrelated with many other areas of law. In administrative law, legal rules and processes that govern administrative decision makers are open to challenge. Under criminal law, breaches of environmental statutes that result in grave harm or possibly death to individuals will be prosecuted as criminal. Civil law can be used to stop pollution from destroying environmental resources, mostly rooted in property. With municipal and land use planning law, urban issues that have a direct impact on the environment, such as zoning, sewage, water, brownfields, redevelopment, etc., are dealt with. Corporate and commercial law, which is concerned with the rights and liabilities of shareholders, bankruptcy, insolvency, and directors' and officers' liability, is critical as corporations are often the ones charged with environmental offenses. Finally, recognizing that the environment is a global matter of universal concern, international law concepts and principles are foremost in attempting to address environmental problems nationally.